City of Stevens Point Public Protection Committee meeting, recorded December 9, 2019.
It's 6:03. I will call the Public Protection Committee meeting to order. We have a quorum, so we can get started. The first on the agenda is an appeal of notice or service charge for property maintenance violation at 456 West Carner Street. Is anyone here from for that appeal?
Does not appear to be.
And there was no one in the hallway.
Okay. So, comments from the committee?
Yeah, I have a couple of comments. Parking on the grass. The tenant at this location said I was not aware parking on owner property was a violation of city ordinance. And I think, that's probably accurate for a lot of people. Parking on the lawn is prevalent all over the city. It's one of my pet peeves. Currently, people are plowing now, snow plowing their driveways, so to speak, and their parking lots on their snow-covered lawns, in the front, on the side, in the backyard. Some are in the front yard, some are in the side yard. Some of these driveways connect to the backyard. I'm seeing those. They've got the equipment for this. They've got the plows, I guess. Anyway, I think number one, the city neighborhood improvement needs to step up enforcement. It is everywhere in the city, and I'm so glad that it's doing what it is, but it's not enough. And the city needs much enhanced communication to inform residents so that they're aware that parking on owner property and off hard surface pavement is a violation of city ordinance. To quote again the tenant there. This particular complaint, or appeal rather, seems to have gone through all of the steps. It was inspected at 10/18, the notice was sent the same day, and a copy was sent to the tenant, including the owner, and to the owner, of course, and then the tenant too. The owner is the tenant's father. They gave them more than 2 weeks, neighborhood improvement did, to comply, simply get the one vehicle off the grass. Reinspection was a couple of days after the deadline. Now there were 2 cars in the backyard. That was 17 days after they'd been sent their notice. They got another notice, $100 service fee, and they finally did comply 22nd of November, not long ago. Those are my comments.
Okay. Alder Dalton, anything to add?
No, I can make a motion. A motion to deny the appeal.
Okay, we have a motion and a second to deny the appeal. We'll take the vote. Those in favor vote aye. Those opposed vote no. So, on the
All in favor?
call the vote.
All those in favor say.
All those in favor say aye.
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 Opposed?
That's probably a better way to
Okay.
Got through that?
So the motion is carried, the appeal is denied. Second item on the agenda is the license list for new operators. Licenses, we'll take them all in one. Chief, any issues with anybody on the list?
No.
City clerk, any issues you have?
Nope.
Okay. So I would look for a motion.
Motion to approve the new operator's license.
I'll second that one. Those in favor vote aye. Aye.
Aye.
Opposed? Motion carries. List is approved. We've got a temporary Class B license for the Boys and Girls Club for the annual Taste of Wine and Cheese on April 3rd, 2020. I believe that's the hangar, the Noel Hangar, 4501 Highway 66, Stevens Point. The licensed operator will be Jeff Tews. Anybody here from that event would like to say anything?
Nope.
Okay. Then I would look for a motion.
Motion to approve the Class B license?
Second?
Okay, we have a motion and a second. Those in favor of the motion will vote by saying aye.
Aye.
Opposed? Motion carried. The license is granted. We have a change of agent on Fisco LLC, 709 Sunset Avenue, Stevens Point. Mary McCuskey, 333 Second Street, will be the agent at Jimmy B's Parrot Club, 916 Maria Drive, replacing James Billing. Chief, any issues there?
No issues with this change.
So I will move approval on that change of agent.
Second.
Okay, we have a motion and a second. Those in favor vote by saying aye.
Aye.
Opposed? Motion carries. We'll take the secondhand jewelry pawnbrokers licenses as one motion, if that's all right. We've got Brody Designs LLC, 1525 Main Street, Brody Rice, owner. Eco ATM LLC, 10121 Barnes Canyon Road, San Diego. The manager on site will be Hunter Bjorkman at 1500 Pinecrest Avenue. And then Eway Sales LLC, 3296 Church Street, Unit F, Stevens Point, Jonathan Reuter, owner.
And there was an amendment that was sent out last week as well for Gruba Jewelers.
That's right. Thank you. Okay. Any issues with any of those establishments?
No, I missed what you said about Gruba Jewelers. I know that they're going out of
They
business.
need their license renewed as well.
Oh, they did?
Yes.
Okay.
And they did apply. It just came in 20 minutes after we did the agenda.
Okay.
So,
We did amend it.
not a problem. Any issues?
And we have no issues with these requests.
Great. So would entertain a motion there.
So moved. to
Okay.
approve the
Have a
licenses.
motion and a second by Alder Dalton and Alder Dugan. Those in favor, vote by saying aye.
Aye.
Opposed? Okay, motion carried. Item number 6 is an ordinance amendment to Chapter 19, an electrical code update. Who from staff would like to address that one? Community Development Director Karnowski.
All right, these are just updates that are required in our electrical code to bring or continue to make sure our code's in compliance with state regulations. These amendments need to be updated and implemented by January 1 of 2020 so we can retain our delegated status.
And no issues with any of the new, just makes everything safer for everybody.
That's the hope.
Okay, any questions from the committee? Questions from the audience? Okay. I will move to approve the ordinance amendments to Chapter 19, the electrical code update.
Second.
Second by Alder Dalton. Any other comments before we vote? Okay. All those in favor, vote by saying aye. Aye. Opposed? Okay, motion carries. Number 7, ordinance amendment for Chapter 3, creating Section 3.56 Administrative Appeals Board. I know this is something we had talked about earlier. Our city attorney will fill us in on what this all involves.
So
I feel like I might have not done the best job of explaining why this is needed last time this came through. So I'm going to try to go about it maybe a little differently than I did before. So there is a provision of state statute that says if you do not have an ordinance that creates an appeals process, a generalized one, then here's the process you have to follow. It's established in state law. So the problem with just having the status quo for the city of Stevens Point, which is essentially saying we don't have a standardized one and we would have to default to that, is that we have these sort of little bits and pieces of appeals procedures scattered throughout our ordinances. For example, what you guys just did earlier tonight with regards to the parking on the lawn. The problem is that person who just defaulted on that could then contact us and say, well, I demand that I have all my full appeal rights under Chapter 68. And you know what we'd have to do? Spin up a procedure for that out of nothing on the fly, provide them with a hearing. You know, it becomes this thing where at best you are creating something ad hoc that is in compliance with the statute and doing a whole bunch of more paperwork and to end up in the same place that you much more efficiently and with a lot more sort of legal clarity could arrive by having this ordinance. So Chapter 68 says that municipalities can opt out of being governed by Chapter 68. If they do so explicitly, it has to say we hereby elect to opt out and all that. There's a case that says if you don't make it explicit, then it doesn't work. But then you have to create your own procedure that is in compliance with the requirements of Chapter 68 and general requirements of due process. So that's what you have before you. There are some slight tweaks to it, as you can see, compared to the first version that came forward at the end of summer. And obviously I can answer any questions and try to clarify anything if need be here. But the general idea is to have something that gives us a very clear roadmap to how appeals will work. And it would take a number of things off of the table for this committee, but it would be creating a lot more clarity for things where we currently don't have an established appeals procedure, but we're required by law to have an avenue for appealing.
Questions from the committee first, then we'll go to the audience.
I guess basically, I understood that from the earlier, and I think this was also brought forth in part because the Alder Phillips was interested in shifting some of those responsibilities, and so my opinion is that having those opinions under the purview of elected representatives, the property violations is an important role, and I knew that going into this role, and I talked to constituents about that process and what happens here. So I have some proposed amendments to the code, and I sent these to the city attorney as well. So I'm going to make a motion for these amendments, and I can read them off, but I also have written copies for us to look at. So the first is removing under the section 1, the determinations reviewable, the issuance of a notice or order pursuant to Chapter 21, which is the property violations. And then under section 1.5, the administrative review board, basically the section outlined the composition of the board, changing it to a 5-person board where the council member who is on it has voting power. I think that is an important part, and I know we went back and forth in prior meetings about that, but I think having a board composed entirely of mayoral appointees kind of removes some of the power that we as elected representatives were granted by people. So I guess I just disagree with that. And then under section 2, which basically just removes from the current code of ordinances the appeals process, which comes to our committee currently, just deleting that since the idea is to keep that under this purview. And I appreciate that this would cover some gaps and be a flexible board, but I would like to maintain some of our responsibilities that we have been, and I don't have a problem with it. So that was a very long-winded motion. So if anyone wants to second that.
You know, I actually appreciate this possibility. I sit as a liaison, and there's not a whole lot a person can do in that situation. It might be helpful, I think, to have at least one council member on this board. So I would second it.
I also agree that because the city has a vested interest, a financial interest in property violations, if someone is sent a violation notice, something is not taken care of, the city sends someone out to do the work, then there's a fiscal impact to the city. So I think the alder should have a vote. It would only be one vote
Yeah.
of 5.
Yeah.
But I agree. I would ask the city attorney to clarify under your item E, the issuance of a notice or order pursuant to Chapter 2113 of the RMC, and also the other part of that motion. Is that something that we could do, or is that a statutory requirement?
So am I being asked to clarify the reasoning behind the alder's proposed amendment? Because I think that would be a question that she could probably answer better
Well,
than I can.
I guess I'm wondering if that's something that
Number one and number 3 on the sheet?
we could even do, or would that violate the state statute? Is there a notice?
Well, I guess my first question would be to ask,
Okay.
Alder Dalton, why,
Why
am
would
am I to understand that you are asking for violations of the property maintenance code to remain under the purview of this body?
Yeah, which is what is section 21.16, the applications for reconsideration, hearing, and appeals that exist in the code.
Can I ask what your reasoning is behind that? Because,
Well, I just explained.
first of all, I can explain why I specifically disagree with that being a good idea. And it's because we know that far and away, that is the type of appeal that we get the most of. And the entire idea behind this is to eliminate legal ambiguity, the push and pull between our procedure and this Chapter 68 procedure. We have the ability to opt out of it and have something where it's 100% clear that this is where the appeals go and this is how they're handled. So to have there just be this parallel process then for the thing that is the largest volume of appeals strikes me as just sort of taking the biggest piece of utility of this whole ordinance and just pitching it away. So I'm still curious to hear what your reasoning is behind that.
Yeah, I guess my response to that would be that previously you had argued that this administrative appeals board would help to cover the gaps in those like strange situations where we didn't have the appeal process. And so I'm totally fine with that, having that process. And I think the biggest reason why maintaining those property violation or review appeals under elected officials is that when a mayoral appointment in a body that is only appointed individuals, they have less need to be responsive to constituents.
That's true.
And so us as a body here, they can vote us out if they really disagree with that. And also, I think us having more participation in that process where we're reviewing the administration and the enforcement is a better dialogue to be having with people about the very ordinances that we have and what may or may not need to be changed. So my fear is that in having a flexible committee that is then going to, whether or not, we should all be doing our diligence and watching those videos if we can't appear at them, that we miss out on that conversation and whatever may need to be altered or improved, or even just our very role to help with how things are administered.
Okay, I understand your point of view on it. I just don't agree with it.
Mayor Wiesa.
For the city attorney, could you tell us what potential ramifications having amendment number 1 and number 3 could potentially pose?
Well, it's pretty simple. It's that for appeals on property maintenance code violations, the status quo would continue, which is that somebody could come before this body, or even not come before this body. Somebody could just default like they did tonight and still say, oh, now I want to avail myself of my rights under Chapter 68, which would start off with having to provide them with a written explanation of the decision, which, I don't know, here's a copy of the minutes. Would we have to, at your next meeting, introduce written findings that you could then approve that could be signed by the chair of this body? Well, I don't know what the answer to that question is, because we have a process here, and then there's a process under Chapter 68, and they don't mesh neatly. The requirements under Chapter 68 are not, they're speaking a different language than what occurs at this body. And what you end up having is essentially this duplication of process. I mean, this specifically, the reason that I drafted this in the first place and brought it forward was we had an appeal that was denied, and then somebody made a request to have this process. And we ended up having to have a hearing where the comptroller treasurer served as the hearing officer, which he was permitted to do because he'd had no role whatsoever in any of the determinations or the orders leading up to it. We had to schedule it with the person. We had to find a room and you know, send out letters saying, here's when it's going to be. And the person didn't show up to that either. And then we had to produce a written finding that Corey had to sign and file it. And then, of course, you know, then
And we're still not done with it.
we're still not done with it.
Yeah, oh my gosh.
So,
Could you explain the next process?
what?
I'm aware of the process that you're currently involved in. I'm not sure all the alders are with the appeal to an administrative
Well,
law judge.
the process that's still ongoing is related, but it's different. That relates to the amount of, the $100 amount of the service fees for failed inspections. So that's a challenge under the Tax Appeals Commission saying, you know, alleging that the $100 fee is impermissibly large. So that's actually a different thing. This body doesn't have purview over that. I mean, you could change it just, you know, by legislative action, you could change that amount, but an appeal of that type would not come here in the first place. But that's the basic thrust. And I think if the idea is to have a heightened level of legislative, i.e. aldermanic participation in this, I would strongly encourage you to look at the composition of the appeals board rather than take the property maintenance appeals out of this process. Because, I mean, we've only ever had one request for a hearing under Chapter 68, and it was with regards to one of these types of matters. So, I mean, certainly there were, I think the very first iteration of this contained more alderpersons. I could be wrong about that.
I think it was suggested, I don't know if it actually was
Yeah.
put to paper.
So, but I can certainly understand the desire to have those determinations remain in the hands of largely or entirely the alderpersons. I think that's a perfectly reasonable point of view.
And if I could continue, the appeals should be evidence-based. If the city did something wrong, we'll own up to it, and that's what the appeals body, whatever that is, should be determining. It shouldn't be based on whether or not the appellant knew that it was against policy or ordinance. It shouldn't be whether or not we agree with it. It shouldn't be whether or not we owe something to our constituents. It should be based on whether or not they did what was alleged. And if we don't like the rules, let's say we don't like the sidewalk shoveling rule, then this body can change it. But the enforcement is what we charge our neighborhood improvement coordinator and their staff to do based on what this body and the council decides we want as ordinances. So I would try and take as much of that political stuff out of it as you can, because the more electeds that you have on that body, the more chance you have to put things in there like, oh, it's in my district, So or I know this person, and you'll still get, I know this person, but, or I don't agree with it, those sorts of things that you might have. And then I would ask also, Madam Chair, that you take each of those amendments individually for a vote, please.
Yeah, good idea.
Yeah, I was going to ask the Alder Dalton if we could amend the motion to remove number 1 and number 3, to take each one separately, 1, 2, and 3. We could go forward with, say, number 2,
Because then we could
there
amend
is
the
hereby created a review board,
Yeah.
and then look at 1 and 3 separately, if you're not opposed to that.
I'm not.
Okay, do we need an amendment?
Does Alder Dugan concur?
I'm,
Is the second
Fine.
okay with that?
yes, yes.
Okay. I think that we agree on number 2, that we would, do we want to vote on that? Let's open it up to comments from, before we take the vote, comments from the audience.
Can I make
Or
one
Alder
comment?
Dalton
Can I make one
first.
comment? I just want to point out that one of my frustrations continuing with this conversation is that we continue to refer to appellants not appearing at this meeting as some sort of default or failure to participate in this, but they are not required to be here. The appealing form is their participation in it, and while, yes, it is beneficial and probably invokes some
Good
of the
argument.
emotional, political part, they're not required, and so they could probably do a better job arguing, but it would only be a more, flushed out representation of their appealing form, so.
Okay, to the audience, Alder Jennings had a comment.
Tori Jennings, Alder District 1. I continue to oppose this process. I think it will weaken the efforts we've been making to do enforcement in the city. If I'm understanding this correctly, it creates another layer of government in the form of a commission that is populated by people appointed by a mayor. And therefore, the appointees we can end up with a committee or commission or board, whatever it's going to be called, of landlords who are protecting their best interest. I did contact an former alder in Madison, and just to see how they do things, and it seems like a much more straightforward, simple process. I had a specific question about grass, but just reading an excerpt from this email from the building inspector there, we ticket and prosecute until they get into compliance. So that's basically how they deal with things. Appeal of the notice would be to the Board of Building Code, Fire Code, Conveyance Code, and Licensing Appeals. The owner would have to fight the ticket in municipal court. Appealing charges for cutting grass, as the example, would first be to me, in other words, the building inspector, and then on to the administrative review board if they do not like my decision.
It's perfect.
It's saying, no, it goes to the building inspector first. So that's not what we're talking about here. So if somebody has, if trying to appeal.
Can I comment on that? So when somebody receives a notice right now from the building inspector or the neighbor improvement coordinator, whomever, the first thing they could do is just call and say, hey, I don't agree with this determination. That's that appeal. But when you say ultimately it can go to the Administrative Appeals Board, that entity that you just mentioned that they have in the city of Madison is identical to what I'm proposing we create right here. So those underlying layers would still exist in the city of Stevens Point. It's just that there's a level of informality. It's, if you have questions or comments about this, you can call this number. And if, find out that something, determination was just flat out made in error, then obviously that can be taken into consideration. But I think the idea that this somehow undermines the seriousness with which we take enforcement in general, I mean, you could end up with a group of alderpersons in the future who don't take these things seriously. So just suggesting, you could have an appeals board whose membership lets all this stuff slide. Well, whomever is the one making the determination could potentially, possibly have that point of view on things. But additionally, whenever you're talking about citations, we don't issue citations for these types of things unless somebody pushes it really, really far. Usually if somebody gets a ticket in municipal court for a violation of the ordinance saying you owe $111.40 and here's your appearance date, it's because they've already had, 6 months of notices and orders or they've completely not responded to any communications whatsoever, or they've violated the same thing in the past, last year, and now they're violating it again. That's the point at which we'd say, we're not going to give you an opportunity to correct it. We're going to issue a citation because you clearly already know the rules and you don't care. And then obviously you're just in municipal court then, and you follow the municipal court procedures. So this is different, and you got to remember as well that this is much broader than just the property maintenance issues. But as you can see, all of our conversations are focusing on that because it's probably going to represent 98% of the appeals you get. But I think what you're describing sounds, to me at least, like it's very, very similar to the system that we would have here if we passed this. And, certainly I wasn't privy to the conversation you had with that person, but.
Just for the record, I would say it's very different, but I don't have enough information in front of me to do that. So I would have to take it up at council. So I apologize to not have more information.
Any other comments from the audience? President Johnson.
Melissa Johnson, District 5, just sort of gathering my thoughts. So I appreciate the work that the attorney put into it. It really was at the request of council. And frankly, I like the quasi-judicial framework of this. Evidentiary rules, being called, sworn in to testify, the right of the chair to issue subpoenas. It seems to me that's a weighty responsibility, and I would hope that anybody in that position would take that very, very seriously, including all of the members of the commission. We can never guard against, you can never have 100% guard against nefarious intent of individuals who serve. I wish we could. Wouldn't that be wonderful? And that we all had this praiseworthy, wonderful intent to serve. I see this as a very good structure, and I think it's fair if someone's being sworn in, a member of our staff, or if it's one of the appellants or their witness, that's pretty serious stuff. And I think the framework is something we want to look at. I do agree that the alder serving on this should have voting rights and not just a liaison. So thank you. That's all.
Anybody else? Okay. I'll bring it back to the committee for comments. Any other, and then we'll restate the motion and we'll go from there. So if...
Take them in order. Just go 1 to 3. Take the motions in order from 1 to 3.
So we would need a new motion. Well, don't we still have to?
We have a motion on the floor to consider these separately.
Okay.
So just start at number 1.
Can I make a comment about
Sure.
number 1 then? That I will entertain the idea of consolidating this, so I will likely not be supporting my First Amendment. And I will be looking to probably alter the composition in number 2.
Okay, so as I understand it, we will vote on item 1 to remove the issuance of a notice or order pursuant to Chapter 21.13 of the RMC under the determinations reviewable. So those in favor of removing that would vote aye. Those opposed would vote no.
No.
No. Okay, so that motion is carried. Number 2, under section 1, we have made, the changes would be, the board shall be comprised of 4 voting members selected from the public at large, and 1 member of the Common Council. We've struck to serve as a non-voting liaison. I agree that the alderperson should have a vote. And then all 5 members shall be appointed by the mayor and confirmed by the council. That's the same. We have struck further down, 3 members of the board shall constitute a quorum. What's struck is, but the common council liaison member shall not count toward forming a quorum. They would, because they would be a voting member. So just a couple of small changes there. Those in favor
Do
of,
we have an amendment to that?
Yeah,
sorry.
I'd like to make an amendment to switch the 4 and the 1. So the board shall be comprised of 1 voting member selected from the public at large and 4 members of the common council.
oh, do we have a second for that? Okay, that amendment would fail for lack of a second.
Can I attempt another amendment?
I'm sorry?
I would like to attempt another amendment, which would be the board shall be comprised of 3 voting members. Oh, wait, no, 2, sorry. 2 voting members selected from the public at large and 3 members of the common council.
Okay, do we have a second there?
Sorry.
I think the point kind of is to take this away from all the alders. If we're going to have that many alders, we might as well just stay with this committee.
Yeah.
So, Alder Dugan.
I just want to comment that, I'm sitting here with you, and you're the one alder on Plan Commission, and all of those people who have been appointed there are very qualified to do that work. And I can't believe that wouldn't happen in this instance, too. So I like the 1 council member and the 4 voting members from the public.
So without any, okay,
I'm
Alder
going to try
Dalton.
one more amendment. Thank you. The board shall be comprised of 3 voting members from the public at large and 2 members of the common council. Because, again, the point being that those board members are not ultimately responsible or responsive to the electorate. So whether their qualifications fit the capacity that they're serving or not, which in the Plan Commission is a more specialized role, I don't even think that whether these individuals from the community are lawyers grants them any sort of responsiveness and accountability to the public, and that is ultimately my concern with the composition of this board. So my amendment, 2 members of council, 3 members from the public at large. All right, I understand silence.
That's a little bit more reasonable, I think. I'm not sure I want
We don't
to
have a
second
majority.
that, but.
It's part of it, too.
Mayor,
Well, and I assume because there's not a second,
It
that's
doesn't
gonna
work.
fail. I do have a
We do it.
comment about this in general, though.
go ahead.
Okay.
Yeah.
So, as with any other body, the mayor recommends appointments, the council affirms that. If you don't believe that the people that are appointed or recommended for appointment by the mayor are qualified to do the job, you vote no. It's that simple, and it's been that way on every other committee. I would hope that someone would say no because of a reason, so we could try and accommodate. But it's not like the mayor gets to appoint all the landlords. That's not going to happen because the council has say in it. If I would recommend nothing but landlords on there, I would expect the council to say no. That simple.
So if I could quickly comment on the composition idea as well. The notion that something where someone is appealing and it relates to their legal rights, that needs to be heard by a group that is directly elected. I can understand that notion. However, if you think about what we actually have right now legally for certain other types of appeals, case in point, the Board of Appeals.
That's right.
If you want to challenge your tax assessment, which has a lot more at stake than a $100 charge for parking on your lawn, that body is not made up of alderpersons. It's made up of appointees who are selected on the basis of having some sort of background or understanding of property valuation typically. And also the Board of Zoning Appeals, kind of similar, but not quite as ubiquitous in terms of everybody's, everybody pays taxes, not everybody has a zoning dispute. So the Board of Zoning Appeals, I mean, you could come in there with your $3.5 million valuation on your piece of commercial land, and it's being heard by a group that's not elected. The other aspect of it, which I hadn't mentioned before just because I think the odds of this actually coming up are really slim, but it could come up, which is that somebody could be appealing a determination that was made by a body of the council or a committee. For instance, obviously we've got it written in there so that you can't go to the appeals board with regards to alcohol licensing and that type of stuff. There's different procedures for that. However, picture somebody who comes in and requests a street closure for a parade. That comes to, or a race or something like that. That comes to this body. And it's not out of the question that somebody would propose one that you'd say, this is poorly thought out and unsafe, and we're going to not approve it. Or it's being proposed for a time of year or a certain time of the day or something that just doesn't work. If somebody wanted to appeal that determination, it would fit within this. And then you could end up with an issue where, okay, well, half of our appeals board is made up of people who are also on this body. And then you've got an issue with them not being able to sit and hear that appeal. Now, I'm not suggesting that that is the biggest concern. I think it's probably pretty unlikely that we're actually going to have that type of scenario arise. And should it happen to arise, well, I guess we'll figure it out somehow. Maybe we can still have a quorum without certain people being on that particular case. But in general, I think the idea that it has to be made up of council members, there's merits to that. There's merits the other way as well.
Yeah, I also kind of feel that way. I think if we make bad decisions on approving appointments, we will likely have to answer to constituents that are angry at our next election. So I feel there is some accountability there. I think that we trust people to make good appointments that won't slant a committee one way or another. And I think that people who have a desire to serve do so from a perspective where they want to do the right thing for the community, as opposed to perhaps something that would benefit their own selves. I think one alder with voting power is probably enough. I think, are we there yet at that number?
That's the proposal on the floor.
Okay. I think Alder Dalton raises some very good points, though, and I appreciate a robust discussion always.
Yeah.
So continue to do that. So we have a motion to go ahead with the board with one alder as a voting member. So those in favor would vote by saying aye.
Aye.
Opposed?
Nay.
Okay, so that's 2-1, the motion carries. So now we're to number 3, which would delete that section 21.16 of the RMC applications for reconsiderations, hearings, appeals is hereby repealed. We have a motion to, I think, to approve that one.
So, yeah, you're voting on the amendment. If you want that amendment, you would vote yes.
yes.
If you don't want that amendment, you vote no.
So those in favor of that deletion would vote by saying aye. Opposed? No. I think that's 3-0 no, so that is
Now you need
denied.
Now you need the ordinance as amended.
I'm sorry?
You need to approve the ordinance as amended.
Okay. So, do I have a motion then with the, we've amended the membership of the committee, so now we need a motion to approve the committee itself, or the appeals board itself.
I
Alder
move
Dugan.
to do just that.
Okay. I'll second that. Any comments? Alder Dalton? No, okay. Anybody else before we vote? Okay, those in favor of establishing this administrative review board with this amendment would vote by saying aye. Aye. Opposed?
Nay.
Okay, so I think we're 2-1 there as well. And that concludes our business, and we will adjourn at 6:47.
Videos of these meetings are available for viewing on the city's website, stevenspoint.com/videos.